Hi, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Today I want to talk about why timing is important in lawsuits. But first I want to say, if anyone has any business litigation questions, want to talk about a potential case you may have, or just want to talk about your business, all you have to do is go to jdelaw.nyc/consult. That's jdelaw.nyc/consult. And you can book a 10-minute phone or a 30-minute in-person consultation right there. All right, timing. It's important, especially for litigation attorneys, to have the right timing in their case. Okay? First off, every case has a statute of limitations. The statute of limitations is how long you have to sue. So, for example, a defamation lawsuit has a statute of limitations of 1 year. That means you have 1 year to bring the lawsuit from when you've been defamed. A breach of contract has a 6-year statute of limitations. So you have 6 years from the breach of the contract to sue on it. Okay? You miss it, you're done. All right? It's that simple. You can't bring a defamation lawsuit 18 months after it happened, and you can't bring a breach of contract 10 years after it happened. Okay? It's just not going to work. You'll get thrown right out. But timing is also important when it comes to making motions and just your overall strategy in litigation. So let me give you an example. I had this case. I represented the plaintiff. The plaintiff was suing on, basically he was owed money on a house deal. Okay? And what happened was they made a motion to dismiss. Now, in my opinion, they had no chance of winning the motion to dismiss. Okay? So they made the motion to dismiss. I don't know why, because it was not a right case for a motion to dismiss. Now, going to the timing issue, I was not going to make a motion for summary judgment early on in the case. There was no way. You know, I figured I needed to do some discovery and strengthen my position. But since they made a motion to dismiss, I cross-motioned, which means a cross-motion is when someone else makes a motion, and on that same date that the first motion is going to be heard, you make your own motion. So I made a cross motion for summary judgment on the one cause of action I thought I could win. And at that motion, I did win. Their motion to dismiss was denied. My cross motion for summary judgment, and again I always like to say a motion for summary judgment is saying that I win based on the facts and the evidence without the necessity of a trial. So on that motion for summary judgment, I won. And I only did it on one cause of action. I couldn't win the other causes of action on an immediate summary judgment, or at least I figured it wasn't ripe for it yet. However, while I was winning that motion for summary judgment, the judge told my defendant that at the end of the day, you're going to have to pay him money, meaning my client. Well, that seemed like a great invitation to me. I made another motion about a week later on summary judgment on every other cause of action. And guess what? I won. That case ended 6 months or a year earlier, all because the other side decided to make an ill-fated motion to dismiss that I, in my opinion, as a litigator would have never done. And this is why timing is important, okay? There was a few different timing issues there. Their timing on the motion to dismiss was just not good. My timing on the cross motion was, number one, I thought I had a good chance, and thus it was good, but also I took the chance because they're already hearing a motion. So I was combating a motion to dismiss with my own motion, and I won it. So that was good timing on me. Plus, I took the judge's direction that the other side was, at the end of the day, was probably going to have to pay me as an invitation for a good timing to do another motion, which I won. So timing in litigation is always important, okay? And it's usually a strategy that can be done at the outset, timing the case along the way. It can also be done as the case moves along, when you look at everything and say, listen, just like with this motion to dismiss, this is my time, okay? Or on the, conversely, you say, it is not time yet. I'm going to get killed if I do it now. But if I wait 3 months or 6 months, or I have this piece of evidence, let me go into that. For example, I have a case I think is very good for summary judgment, but they have threatened a piece of evidence that can get in the way of me winning this motion for summary judgment. Maybe threatened is not the right word, but it's mentioned in their documents. So, and I don't have it. So I'm putting off my motion for summary judgment, even though I think I can win it, till I actually get that document and know for sure. Right? So that's my timing on it. I'm now asking for that document. When I get it, I'm going to look over it, find any way I can to discount it, to say it's not worth anything, why I should win the motion for summary judgment in spite of it. And I'm going to take that document and use that and time that with my motion for summary judgment. That is how a good attorney uses timing to their advantage. Okay? Now, once again, if you have any questions on this or business litigation in general, or you just want to talk about your business with me, all you have to do is go to jdelaw.nyc/consult. That's jdelaw.nyc/consult, and you can book that 10-minute phone or 30-minute in-person consultation. Now, remember, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Thanks for watching and listening.